open this hearing of the review of dangerous, affected or insanitary building policy. Can I call for a chair, please?
I'd like to nominate Philip Redmond as chair.
And I'd like to second it, please.
Right. Well, I'll put that motion. We have a mover and a seconder. All in favour?
Aye.
Right, thank you very much. Do we have any apologies? I think we're all here, so there won't be any. Conflicts of interest? There are no conflicts of interest, so we'll move on to item 4. Wee bit of noise in the background for those listening. Who's going to speak to the report? We've got present Warren, Gina Maxwell and Greg Wilson. So,
You haven't introduced the panel.
oh sorry, I haven't introduced the panel. The panel today is myself, Philip Redmond. On my left I have Councillor Kirsten Barnett, and on my right Councillor Wendy Doody. Thank you.
Thank you.
We're no longer anonymous. Is someone speaking to the report at this point? Warren?
Can I ask a question? Can I take it that the original report has actually been read?
Yes, you can take that as read.
Excuse me, please, can you use your microphone as we're live streaming?
Sorry, I didn't quite catch that.
Live streaming, so you
I
need
see,
to use
right,
your
okay.
microphone.
Righto, yes, okay. Can I take it that this report has been read?
Yes, you may.
Okay, righto. On that basis, then can we have a conversation about the content of the report and any proposed amendments to that report?
Right, are you wanting to discuss amendments to the policy document at this point, or will that come under matter 5?
No, this is from the conversation we had prior to this meeting regarding the proposed amendments to the policy.
Right, okay.
I see, right, okay.
Yeah, do you want to talk about that now under the report?
I think that would be worthwhile because there's a wee bit of time required for this.
And then we move on to the hearing panel deliberations in matter 5.
Okay.
So, okay, we'll cover. Do you want to speak to
Happy
those?
to have a conversation around that because we've got Greg who knows this inside out, and Greg has had a chance to read the commentary that's been delivered so far for a conversation. So, should we have that conversation now?
Yes, thank you.
Okay. So the first point was in the introduction to 1, the meaning of affected building. There's an error in that where it references section 132, and in fact, what it should have is section 121A.
Right.
Okay.
Thank you.
We would agree with that
Yes.
as an amendment. Yep. Then we have got on the following page under policy objective, point 3, the purpose of the policy. We have got changed the words the public to people. We don't have any concerns about changing that. That's fine. Then we want to add a bullet point down the bottom which reads, earthquake-prone buildings are managed under the Building Earthquake-Prone Buildings Amendment Act 2016 and are therefore excluded from this policy. Now, Greg has a commentary regarding that.
Can I please just ask a question, please? What made you change the public to people? What was your reasoning behind that?
The chairman came in and said, I think we should change this to people, and I thought, well, why not? I am open for a conversation on that, to be fair.
I thought people reflected what we're trying to achieve rather than just the public. At the end of the day, I'm not too concerned either way,
I
but
just
I just thought people
Yeah. I just want
meaningful.
to get what you're meaning by that. Yeah. So this is people in a private capacity around a place or in a public arena?
So if I can say it, it's I had a review of some of the other policies that other councils have done, and they're very much gone along the way of the chairperson's wording, if you like, and actually put people in there
Okay.
to encompass the actual staff inside the building as well, not just the members of the public going into the building. So it becomes very much a catch-all.
Thank you, that's
Phrase.
important.
Right, thanks Warren, carry on.
Thank you. Now, Greg, you put some commentary on this just down here. Do you want to speak to that?
So the other thing was that we mentioned the Earthquake Prone Buildings Amendment Act 2016 in relation to earthquake prone buildings being managed under it. All those sections in the Act from 1st of July 2017 were actually put into the Building Act. So they're all encompassed, and the idea was to have everything in a one act, if you like. So that gave them the power to do it. So the sections relating therefore to earthquake prone building and all the other ones are now encapsulated in the Building Act.
So that means we should be putting under the Building Act sections XXX, whatever the sections are, instead of Building Earthquake Prone Buildings Amendment Act 2016.
Yeah, I suggest we put Building Act 2004.
2004.
Would we be able to reference the specific sections that cover earthquake prone buildings? Or is it throughout the Act?
It's throughout the Act, but they've
Right.
specifically put in those sections which the chairperson alluded to under the Building Earthquake Prone Amendments Act. They've put those all into the sections in the Building Act now, so it's from 133 onwards. They're all captured in there now.
Are you suggesting then that we refer to the Building Act rather than the Amendment Act?
I think now we're past that 1 July 2017 when they were adopted into this Act. We probably just put the Building Act 2004.
Okay, so moving on down to item 4.1, assessment criteria. So there's a suggestion that we put an extra bullet point down the bottom which would say the assessment will be made in accordance with section 121 and 123 of the Building Act. This will include, and this is the addition, if the building is an affected building. Do we have any viewpoint on adding that, or
What's the definition of an affected building? Sorry.
Greg, do you want to speak to that?
It's, sorry, thank you. It's actually, by default, all related to a dangerous building. So off the top of my head, and I'm going to it now, it's adjacent to, opposite, or connected to a dangerous building.
Thank you, Greg. It's defined on page 1 under number 1, meaning of affected building. We corrected the section. And I guess what we're really looking at here is introducing the concept of an affected building, which wasn't in the previous policy.
It's a distinct change from what was in, and it's one of those meanings that have come about from the Building Amendment Act on earthquake prone buildings, so they've added an extra category in there.
Just, Mr. Chair, does the fact that that hasn't been consulted on and may affect additional owners, does that pose a problem for this hearing?
I don't believe so. We consulted on dangerous, affected and insanitary buildings. We're just looking for the policy to reflect essentially the wording of the Building Act and our obligations to have a policy.
So that was one of the reasons, Councillor Barnett, why it actually had to go out for public consultation, was
exactly.
that extra definition that we needed to.
Oh, I see. Yep.
So we're agreeing we will put that additional bullet point in?
That's right.
Okay, and then we go down to 4.2, taking action on dangerous, affected and insanitary buildings. So the addition of an extra bullet point, which is we will consult with the owner if any affected building and decide on appropriate course of action. Now, Greg has got a commentary here regarding section 133 AB. Do you want to speak to that, Greg? Just that one there.
Yeah, that was more or less along the line that came into effect on the 1st of July 2017, when the Building Act Amendment came into being. So there's a definition of meaning of earthquake-prone building directly in the Building Act now, rather than the Building Amendment Act. Because one of the biggest changes was, and for the councillors that were around during the earthquake time, was that the definition of an earthquake-prone building helped us resolve a lot of issues at that particular time. And then they amended the Act, and an earthquake-prone building could be dangerous. It can no longer be dangerous because it's under... So it's morphed into a different beast, I suppose we're saying. But one of the things that everyone was very concerned about was providing one document which encapsulated everything to do with buildings and provided a pathway for councils and building owners to work together to resolve some difficulties. And one of the pleasing things was we've now got it in one piece of legislation, which makes it easier to discuss with people and to work towards equitable solutions where we can.
Councillor Barney.
Sorry, just a question on this. In the situation there was a dangerous or insanitary building, the affected building owner was next door. We consult with them, but they don't want to do anything and they're going to ignore it. What powers would we have under this particular policy?
I suppose there's a distinction between powers that we could use and actions that we would prefer to take.
Yes.
Now, up until now, we've had a very, very, very good relationship with most building owners. Yes. And it's normally if you provide in the form of them a wee bit of assistance, perhaps an engineering brief or some sort of act that they can actually see that there is an issue. We haven't had one that we've had to initiate legal proceedings and go to court. Not saying it won't happen in the future, but there are provisions and powers. However, you've got to be very careful of those because they come at quite a cost. So one of the things that council can do is actually take action to remove that danger, which means we actually have to pay for it and then recover it through rates and those sorts of things. So up till now, we haven't had to go down that line, but there is provision in the Act for us to do it. And I see in some recent legal papers that Wellington City Council has done exactly the same thing for one building owner who was reluctant to engage with them and to work something out. So they've actually gone and done some work.
I'm just worried about the risk to council decide an appropriate course of action is quite loose. But you're saying it's covered by the Building Act, that we still have remedy under enforcing the Building Act?
We can go down a path to remediate or to resolve the problem.
Yes.
However, those sorts of things are a last resort but there is provision to
There is provision to cover that. Thank you.
Would I be correct, Greg, in thinking that the remedy is really against or with the owner of the dangerous building, and you may need to consult with the owner of the affected building as to whether they could continue to occupy the building, for example, depending on the risk?
That's a very, very, very valid point, and that's exactly what has happened during the seismic events of 2011. So we as a council and council staff always engage with the building owners anyway. I mean, that's our first port of call. And I think we've seen the benefit of that with what's happened in the urban centres around here. So before any action is taken, there's always meetings, there's always discussions, there's always workshops, and often you'll find that the building owner will come up with a solution of his own that we can actually work with and live with. And by allowing that to happen, there's normally a reasonable flow-on effect.
So would I be correct in thinking that the addition of that last bullet point, consult with the owners of affected buildings, is really to cover an omission possibly that there was no mention of how you interacted with the affected building owner?
Yeah, what I like very much about that addition of that last sentence is it actually qualifies what we actually do now anyway.
I will also just note here that we do actually say notify the owner, the owner's agent, but what we don't do is say we will consult with the owner, because they are quite different. You know, so I take the point, I think it's valid.
The notification refers to the owner of a dangerous or insanitary building, doesn't it?
Oh, I see, you mean the subtlety difference of the affected building here.
Can I please just ask a question?
Not unreasonable to know about it.
Judy. Any, these buildings that are affected in that, can they still be used for rental purposes or not? Because this is a question that concerns me. Thank you.
So if I may, that would be the actual risk, not the perceived risk, but the actual risk. So you would, any that we would have that, we would have a chartered professional structural engineer as well as council staff in discussion or consultation with the owner of the dangerous building and affected building would have a round table. So what would happen, I'll give you an example perhaps, is the old chemist shop, Greg Knight chemist shop that used to be along the street next door. So they had Robbie's, which was obviously providing a huge concern. So we either had to shut the whole tenancy, and let's be honest, pretty important in town. So we designed partition walls that would take, obviously if there was a bit of a rumble and some stuff fell off, it would actually be safe, and they lost a wee bit of the building, but they could continue to use the building. So that's the sort of things that you would look at doing. The last resort, or the least likely scenario, is we would shut the building down. We would work at some solution to make it work for them. Maybe reduce space, maybe those sorts of things, but we would look at doing that. It might also be putting a couple of containers down the side to limit any fallout. So.
Thanks very much for that answer. That's very helpful in the hearing.
Okay, so turning over the page, under section record keeping. So we're talking about any building identified as dangerous or insanitary will have a note placed on it. So the question that's been raised here is, should we have a note on an affected building? Is that what the intent of that was, Philip?
Yes, I wondered in terms of a limb, the council is obliged to disclose any information it knows about a particular property, and whether you should be disclosing that a building is affected on the limb is the question. It wasn't covered in the record keeping section.
Okay, so I've had a initial conversation with Marie from customer service who looks after this. She said, well, that's an interesting question. So she is going to have a look at the GEMO Act and also on the listserv for the other councils and ask how other councils manage this, and then come back to us with a suggestion. But I think there's sense in the issue that's been raised here. Because if I was buying a building that was affected and I didn't know, then I'd be pretty disappointed to think that to find out I didn't know. Yeah, absolutely.
So can we as a panel consider including affected buildings, or would your recommendation be to wait until we hear back from Marie, in which case we'd need to adjourn this hearing at the end?
If I could make a comment that a dangerous and insanitary building notice is recorded on the property file now, and then obviously if there's any remedy to that, because we've got none outstanding at this stage, then there's another note recorded on the limb to obviously say it's just like a service request or insanity. We're going to have that the situation is being resolved. So I don't see it as any different from having a dangerous or insanitary building notice that goes out on the limb as it is now.
Sorry. Just to clarify that then, if I'm the owner of an affected building, is that dangerous notice, for example, going to be referred to in my limb?
I don't think you actually could do that. I think you'd be, if it was an affected building, it would be affected building notice, but it would have some description on it why it was affected.
So you're saying that would be in the limb, in your view?
Yeah.
Right.
Okay.
Yes.
Sorry.
No, that was something that I, when reading through it, I just ringing a bit few alarm bells to me for the property that's adjacent to it. So, and listening to what you had to say, if someone wanted to sell that and it wasn't on the limb, then that is a problem. But how do you really, apart from doing that affected on their limbs, how else can that be notified?
Do you want to answer that, Greg?
Okay, so with a dangerous or insanitary or affected building, there's a notice attached to the building. So you've got to attach it to the building.
For the affected building.
Yeah, that's what I'm suggesting. It'll have an affected building notice on it. But, sorry? Well, we haven't actually,
So,
we haven't actually done the
but if we
affected
had one,
building notices. My suggestion is yes, because at the end of the day, the public have got a right, or anyone has a right to know. By the same token, when that's rectified or remedied, then that needs to go on there as well, and a note to say that it's been lifted or been resolved. The other thing is that, you know, we're not hard to get hold of. I'm not. We would have discussions, I would envisage, if any of this, and I've had them before where people have tried to sell buildings. So if you're straight out and straight up with them and tell them what's there, it normally works out reasonably well. But as far as I'm, you know, they have a right to know, and I think we have a legal responsibility.
Thank you, that was the question. What's our legal obligation?
So the amendment to record keeping would be any building identified as dangerous, affected or insanitary will have a note placed on the property file.
yes.
The limb will note that the building is dangerous, insanitary or affected. So
Yes.
you're happy with that? Right. Okay, carry on,
Sorry,
please.
okay, so just rolling down the page, we're down to an addition of item 4.3, which is regarding costs. It isn't very clear in the policy. So the addition of something straight out of the Act, which basically says, Council may issue a notice under section 1242C of the Act, requiring work to be carried out, and that work under the notice issued by councils is not completed or proceeded with reasonable speed. Council may invoke its powers under section 126 of the Act and apply to the District Court to gain authorisation to carry out work required in the notice. If council carries out the building work, it is entitled to recover costs associated with that work from the building from the building owner as set out in section 1263 of the Act. I think that makes it very clear.
I think from what Greg said earlier, the council has never actually had to do that. Is that correct?
Yeah, it's the worst case scenario, isn't it?
It is.
Yeah, that's right. But it is a, you know, shall we say, a fallback position.
Right. Does Gina or you wish to add anything further?
Nothing from me, Philip.
Councillor Barnett, yes?
While this is slightly outside the scope of what we're doing today, there's obviously been concerns in the submission about earthquake-prone buildings, and I just wanted to quickly ask what is being done to communicate with the public about our current status of earthquake-prone and likely to be earthquake-prone in the next 10, 20 years, particularly in the private realm.
I'll have a stab at answering that. So every year I have to do a document for Ministry of Business, Innovation and Employment, which lists our earthquake-prone buildings, because if you go around the street now, you'll see more and more plaques attached to buildings. So that council's, if you like, legal responsibility once we've identified and gone through the process. On the buildings, they give a rough indication of the seismic capacity of them and a date by which they have to be remedied by. In the last report that I did for MB, I've said that, to the best of knowledge, we've got no unidentified earthquake-prone buildings. There's a couple going through reassessments at the moment, but they've been identified as likely earthquake-prone. So we're in a pleasing environment that we can actually report on things like that. And the other thing is, and you've probably driven through from Woodend past Judge John Bransgeeson's, his two priority buildings down there, and you'll see one of them's shrouded or wrapped up at the moment. That's being strengthened. His solicitor's building it's got a live building consent to strengthen as well. The old BNZ building, I think we're all familiar with that. Obviously got Jared Hazeldine and Jed Pearce owning that, and that's being done. So we're actually, and we've got a meeting with Kaipoi Mill owners in a couple of weeks' time to actually discuss where we're going with that building as well. So we've only really got one priority building outstanding, or two of them, once those are sort of rectified. So they're the 7.5-year plan, if you like, or the timeline. One would think, well, it looks like we'll have all of them well and truly strengthened, demolished, we'll put a wee bit of that in there, enshrined, well before the due date. So that's the ongoing, if you like, advantage of working with people.
Right, thank you, Greg. That explains that. We bear in mind, of course, that earthquake-damaged buildings are outside the scope of the policy and are specifically excluded. Unless you've got anything further to add, I'll move the recommendation A to C under matter 4. Is there a seconder? Councillor Barnett. Right, well, I think we've had a discussion, so I'm not proposing to say anything further here. We'll move on to the hearing panel deliberations next. Do you wish to speak, Councillor Barnett?
Yes, it's interesting to note that in terms of submissions, we really didn't receive any on the matter itself. And so I believe that the policy is obviously quite well accepted. There's no red flags for me in the fact that I think it's something that hasn't had a major effect in our district, obviously. Otherwise, we would have had more people knocking on the door to talk to us about it. So it's good to tidy it up and actually make sure that we cover the affected beside it. So I'm really comfortable with the recommendations in the report.
Councillor Dooley?
With just a few little tweaks, I'm actually really happy with it as well. It's something that we have to do, and to bring in that affected is, to me, is really important. So, and that covers those other buildings that have that are beside one that is a dangerous one. So, I'm happy with where we've come to over this. Thank you.
Thank you, Councillor Dooley. I think Councillor Barnett raised the topic that we weren't overwhelmed with submissions. In fact, there were really none on point as such. It did appear to be an unusual topic dangerous, affected or insanitary buildings policy. Hardly likely to set the world on fire with that description. But it is an important matter nonetheless, and it is an interesting small area of policy that under the Act we do have to have a policy, and we do have to review it every 5 years. So having said that, I'll now put the motion. All those in favour? Aye. Opposed? Carried. Thank you. We'll now move on to item 5, deliberations. We have the statement of proposal, the policy with the tracked changes plus the further amendments that have been discussed previously. And we also have the outcome of the consultation with the Bang the Table reports. So, Warren, do you wish to say anything at this point?
No, I think we've had a fairly broad conversation around this, and I accept the recommendations that have been proposed, changes that have been made. So I think with the bit of fine tuning, we'll have something that will be really useful.
Right, any further discussion from my colleagues? We don't actually have a motion here.
No, we don't.
But I'm just wondering the best way of getting the policy onto the table with the amendments.
It needs to be referred to the DPNR.
Sorry, we're going to council on the 7th or 14th of December.
Right.
So we can just recommend the policy to go to council.
Right. Well, if there's no further discussion, we had a good go through with the terms of the policy. I'll move that the policy as amended be referred to council for adoption at its meeting November, December. Gina?
December to council.
At the council's December meeting. Is there a second? Councillor Barnett, any further discussion? I'll put the motion. All in favour say aye.
Aye.
Opposed? Carried. Well, if that's the case, I'll thank you for your attendance, including Kay over on the left, keeping the records, and declare the meeting closed. Thank you very much.